Chapter 42. Appeals. 42-1. An appeal is the transfer of a higher court of a judicial case on which judgment has been rendered in a lower court and is allowable only to the party against whom the decision has been rendered. The parties shall be known as the appellate and appellee. An appeal cannot be made to any court other than the next higher except with its consent. 42-2. Only those who have submitted a regular trial are entitled to an appeal. 42-3. The grounds of appeal are such as the following: any irregularity in the proceedings of the lower court, refusal of reasonable indulgence to a party on trial, receiving improper or declining to receive proper evidence, hurrying to a decision before all the testimony is taken, manifestation of prejudice in the case, and mistake or injustice in the judgment and censure. 42-4. Notice of appeal may be given to the court before its adjournment. Written notice of appeal with supporting reasons shall be filed by the appellate with both the clerk of the lower court and the clerk of the higher court within 30 days of notification of the last court's decision. Notification shall be deemed to have occurred on the day of mailing if certified, registered, or express mail of a national postal service or any private service where verifying receipt is utilized, the day of hand delivery, or the day of confirmed receipt in the case of email or facsimile. Furthermore, compliance with such requirements shall be deemed to have been fulfilled if a party cannot be located after diligent inquiry, or if a party refuses to accept delivery. No attempt should be made to circularize the courts to which appeal is being made by either party before the case is heard. 42-5. It shall be the duty of the clerk of the lower court to file with the clerk of the higher court, not more than 30 days after the receipt of notice of appeal, a copy of all proceedings in connection with the case, including the notice of appeal and the reasons therefor, the response of the lower court, the evidence, and any papers bearing on the case, which together shall be known as, quote, unquote, quote, the record of the case, unquote. And the higher court shall not admit or consider anything not found in this record without consent of the parties in the case. Should new evidence come to light, the case should be remanded to the lower court from which the appeal was made, unless both parties consent to admit the new evidence and proceed with the case. 42-6. Notice of appeal shall have the effect of suspending the judgment of the lower court until the case has been finally decided in the higher court. However, the court of original jurisdiction may, for sufficient reasons duly recorded, prevent the appellate from approaching the Lord's table, and if an officer, prevent him from exercising some or all of his official functions until the case is finally decided. BCO 31-10, 33-4. This shall never be done in the way of censure. 42-7. If a lower court shall neglect to send up the record of the case or any part of it, to the injury of the appellate, it shall receive a proper rebuke from the higher court, and the judgment from which the appeal has been taken shall be suspended until the record is produced upon which the issue can be fairly tried. 42-8. After a higher court has decided that an appeal is in order and should be entertained by the court shall hear the case, or in accordance with the provisions BCO 15-2 and 15-3, appoint a commission to do so. At the hearing, after the record has been read, each side should be allotted not over 30 minutes for oral argument, the appellate having the right of opening and closing the argument. After the hearing has been concluded, the court or commission should go into closed session and discuss the merits of the case. The vote then should be taken without further debate on each specification in this form. Shall this specification of error be sustained? If the court or commission deem it wise, it may adopt a minute explanatory of its action, which shall become a part of its record of the case. The court or commission shall designate one of its members to write the opinion, which opinion shall be adopted by the court or commission as its opinion. 42-9. The decision of the higher court may be to affirm in whole or in part, to reverse in whole or in part, to render the decision that should have been rendered, or to remand the case to the lower court for a new trial. In every case, a written opinion shall be prepared, and a copy of the opinion and judgment entered will be delivered personally or mailed to the lower court and the appellate with a written receipt required. 42-10. An appellate may represent himself or be represented as provided in BCO 32-19. 42-11. An appellate shall be considered to have abandoned his appeal if he fails to appear before the higher court in person or by counsel for a hearing thereof after he has been properly notified, but an appellate may waive in writing his right to appear with permission of the court and not be considered to have abandoned his case. In case of such failure to appear, the judgment of the lower court will stand unless the appellate gives the court a prompt and satisfactory explanation. 42-12. If an appellate manifests a litigious or otherwise unchristian spirit in the prosecution of his appeal, he shall receive a suitable rebuke by the appellate court. Chapter 43. Complaints. 43-1. A complaint is a written representation made against some act or decision of a court of the church. It is the right of any communing member of the church in good standing to make complaint against any action of a court to whose jurisdiction he is subject, except that no complaint is allowable in a judicial case in which an appeal is pending. 43-2. A complaint shall first be made to the court whose act or decision is alleged to be in error. Written notice of complaint with supporting reasons shall be filed with the clerk of the court within 60 days following the meeting of the court. The court shall consider the complaint at its next stated meeting or at called meeting prior to its next stated meeting. No attempt should be made to circularize the court to which complaint is being made by either party. 43-3. If, after considering a complaint, the court alleged to be delinquent or in error is of the opinion that it has not erred and denies the complainant may take that complaint to the next higher court. If the lower court fails to consider the complaint against it by or at its next stated meeting, the complainant may take that complaint to the next higher court. Written notice thereof shall be filed with both the clerk of the lower court and the clerk of the higher court within 30 days of notification of the last court's decision. Notification shall be deemed to have occurred on the day of mailing, if certified, registered, or express mail of a national postal service or any private service where verifying receipt is utilized, the day of hand delivery, or the day of confirmed receipt in the case of email or facsimile. Furthermore, compliance with such requirements shall be deemed to have been fulfilled if a party cannot be located after diligent inquiry, or if a party refuses to accept delivery. 43-4. Notice of complaint shall not have the effect of suspending the action against which the complaint is made, unless 1/3 of the members present when the action was taken shall vote for its suspension until the final decision in the higher court. 43-5. The court against which complaint is made shall appoint one or more representatives to defend its action before the higher court, and the parties in the case shall be known as complainant and respondent. The complainant himself may represent his complaint, or he may obtain the assistance of a communing member of the Presbyterian Church in America who is in good standing in presenting his complaint. 43-6. It shall be the duty of the clerk of the lower court to file with the clerk of the higher court not more than 30 days after receipt of notice of complaint a copy of all its proceedings in connection with the complaint, including the notice of complaint and supporting reasons, the response of the lower court, if any, and any papers bearing on the complaint. If the clerk of the lower court shall neglect to send up the proceedings on the complaint, he shall receive a proper rebuke from the higher court, and the act or decision complained against shall be suspended until the proceedings are produced, so that the higher court shall fairly consider the complaint. 43-7. The complainant shall be considered to have abandoned his complaint if he fails to appear before the higher court in person or by counsel for a hearing thereof, after he has been properly notified, but a complainant may waive in writing his right to appear with permission of the court and not be considered to have abandoned his case. In case of such failure to appear, the judgment of the lower court will stand unless the complainant gives to the court a prompt and satisfactory explanation. 43-8. Subject to the provisions below, after the higher court has decided that the notice filed with its clerk was timely and that the complaint is otherwise in order for it to be heard by the higher court, it shall hear the complaint, or in accordance with the provisions BCO 15-2 and 15-3, appoint a commission to do so. Ordinarily, the court or its commission shall schedule a hearing in a manner that reasonably accommodates the schedules of the respective parties and affords each party a prior opportunity to file a written brief upon such terms, and in accord with a briefing schedule established by the court or its commission in the reasonable exercise of its discretion. 43-9. At the hearing, after all the papers bearing on the complaint have been read, the complainant and respondent will be given the opportunity to present argument, the complainant having the right of opening and closing the argument. After the hearing has been concluded, the court or the commission should go into closed session and discuss and consider the merits of the complaint. The vote should then or later be taken as to what disposition should be made of the complaint, and the complainant and respondent notified of the court's decision. 43-10. The higher court has power in its discretion to annul the whole or any part of the action of a lower court against which complaint has been made, or to send the matter back to the lower court with instructions for a new hearing. If the higher court rules the lower court erred by not indicting someone, and the lower court refers the matter back to the higher court, it shall accept the reference if it is a doctrinal case or case of public scandal. BCO 41-3. Chapter 44. Vacated. Chapter 45. Dissents, Protests, and Objections. 45-1. Any member of a court who has a right to vote on a question and is not satisfied with the action taken by that court is entitled to have a dissent or protest recorded. None can join in a dissent or protest against any action of any court except those who had a right to vote in the case. Any member who did not have the right to vote on an appeal or complaint, BCO 39-2, and is not satisfied with the action taken by the court is entitled to have an objection recorded. A dissent, protest, or objection shall be filed with the clerk of the lower court within 30 days following the meeting of the lower court, or with the clerk of the General Assembly before its adjournment. 45-2. A dissent is a declaration on the part of one or more members of a minority expressing a different opinion of the majority in its action on any issue before the court, and may be accompanied with the reasons on which it is founded. 45-3. A protest is a more solemn and formal declaration by members of a minority bearing their testimony against what they deem an improper or erroneous action on any issue before the court, and is generally accompanied with the reasons on which it is founded. 45-4. An objection is a declaration by one or more members of the court who did not have the right to vote on an appeal or complaint, expressing a different opinion from the decision of the court, and may be accompanied with the reasons on which it is founded. 45-5. If a dissent, protest, or objection be couched in temperate language and be respectful to the court, it shall be recorded, and the court may, if deemed necessary, put an answer to the dissent, protest, or objection on the records along with it. Here the matter shall end unless the parties obtain permission to withdraw their dissent, protest, or objection absolutely or for the sake of amendment. Chapter 46. Jurisdiction. 46-1. When a church member shall remove his residence beyond the bounds of the congregation of which he is a member, so that he can no longer regularly attend its services, it shall be his duty to transfer his membership by presenting a certificate of dismission from the session of the church of which he is a member to the church which he wishes to unite. When the church of which he is a member has no session, or for other good reasons it seems impossible for the member to secure a certificate of dismission, he may be received by the session upon other satisfactory testimonials, in which case the church of which he was a member shall be duly notified. 46-2. When a church member shall remove his residence beyond the bounds of the church of which he is a member into the bounds of another, it shall be the duty of the teaching and ruling elders of the church of which he is a member, as far as possible, to continue pastoral oversight of him and to inform him that according to the teaching of our Book of Church Order, it is our duty to transfer his membership as soon as practicable to the church in whose bounds he is living. It shall also be the duty of the church from whose bounds the member moved to notify the teaching and ruling elders of a church into whose bounds he has moved, and requests them to take pastoral oversight of the member. with a view of having him transfer his membership unless BCO 18-7 applies. If a member, after having thus been advised, shall neglect for 1 year to have his membership transferred, the session shall then proceed according to BCO 38-4, except in special cases such as servicemen, students, etc. The name of any member whose residence has been unknown for 1 year to the session shall be removed from the roll, and such names are not to be counted in the annual statistical reports, though active or mobile should be recorded in the session minutes. If such a person at a later date should appear or desire transfer of his or her letter, the session will inform the governing body of the inquiring church of their action in removing said person from their roll. 46-3. Members of one church dismissed to join another shall be held to be under the jurisdiction of the session, dismissing them until they form a regular connection with that to which they have been dismissed. 46-4. Associate members are those believers temporarily residing in a location other than their permanent homes. Such believers may become associate members of a particular church without ceasing to be communicant members of their home churches. An associate member shall have all the rights and privileges of that church with the exception of voting in a congregational or corporation meeting and holding an office in that church. 46-5. Vacated. See 38-4. 46-6. When a presbytery shall dismiss a minister, licentiate, candidate, the name of the presbytery to which he is dismissed shall be given in the certificate, and he shall remain under the jurisdiction of the presbytery dismissing him until received by the other. 46-7. No certificate of dismission from either a session or a presbytery shall be valid testimony of good standing for a period longer than 1 year, unless its earlier presentation is hindered by some providential cause, and such certificates given to persons who have left the bounds of the session or presbytery granting them shall certify the standing of such persons only to the time of their leaving those bounds. 46-8. When a presbytery shall divest a member of his office without censure or depose him without excommunication, it shall assign him to membership in some particular church, subject to the approval of the session of that church.